minus permission dimension cases, what we do have to call this. It's a human CRP was restoration of human reason.
Who's for that?
Mr. Bulana.
From date is for judgment item 1, CR 28 of 2014.
These civil division petitions are dismissed. The order will be uploaded. By today itself.
This will not affect you.
I have already said. Because those findings could be that I have already taken care of. Like the paragraph here. It is made clear that any observation made in this judgment will have no bearing on the issues to be decided on merits by the learned trial court based on materials to be brought on record.
From supplementary list for orders verified item 1, first appeal 153 of 2018.
क्या defect है आपको?
Office has pointed out some defects, but the CC of the award has already been filed with the CMP, my lord. That is annexed. That is the part of the spine.
CMP कहाँ?
CMP.
And authentication fee?
That has also been paid.
FA number 153 of 2018. Learned Counsel for the appellant submitted that the certified copy of the reviewed judgment with authentication fee has already been filed in the petition seeking restoration of the appeal. Office is directed to place the certified copy from the CMP in the records of this case.
When there is award value, my lord, I have clearly, rightly stated the award value. But if the directed, I will clearly mention it on the second page. I have given it already.
The Learned Counsel has also submitted that the award value has already been mentioned in page number 2 of the memo of appeal. And value of claim 15 lakhs, value of appeal 8,000 per dispute. Anyways, however he submits that, he may be, however he is permitted to do the needful to clearly state the same. आगे बताइए.
One limitation petition there. That may
Substitution किसका?
Substitution is the Sodhana Vedya, the plant number 1, that is expired. Leaving behind Moti.
When did he expire? When did he expire?
On 6/3/2020.
During pendency or after?
During pendency. We have filed in the
During the pendency of this appeal?
This appeal. We have filed in the year 2000.
Where is the wakalatnama of the legal
That
case?
is next along with that.
Along with
CMP, my lord.
CMP का वकालतनामा अलग?
We have filed one वकालतनामा.
एक वकालतनामा एक केस में फाइल कर दीजिएगा, सब केस के लिए हो जाएगा.
CMP has been allowed, my lord.
So what?
ठीक है, okay. I will file the fresh one.
IA number 4478 of 2022 has been filed seeking substitution of the appellant number 1. Also, for the appellant submits that he shall file wakalatnama on behalf of legal heirs and successors, on behalf of the proposed legal heirs and successors of appellant number 1. Limitation,
There is limitation of as per 4 months 27 days for which limitation is
IA number 2487 of 2020. यहाँ पे देखिए साल में लिखिए कब तक
2022.
2022 has been filed seeking confirmation of delay. Post this case on ऐसा कोई similar matter आ रहा है?
It will already have to file मुकल्लमनामा
कब
on 24th of March.
तो फाइनेंस पे जब
कोई बात नहीं, उससे कोई लेना देना नहीं. Post this case on 4th of April 2025 हो जाएगा 4 अप्रैल तक under appropriate heading. In the meantime, it will be open to the respondent to file counter affidavit to one or the other interlocutor. इसका क्या है? अच्छा सर.
Item 2, first
If
appeal.
required, the office may carry on further study.
Item 2, first appeal 173 of 2018.
बताइए.
CC has already filed along with the CMP.
और आगे आइए क्या है?
I have appeal value which I will mention.
Same.
Same.
और
And
limitation
is
है.
there.
Limitation है.
And also substitution petition is there
Of
of appellant number 1 Jaldar Munda
who expired when?
expired on during the pendency of this appeal on 17 to 2022 leaving behind with 3 sons.
Respondent कौन है इसमें?
I will file a fresh मुकल्लमनामा of 3 sons.
Identical order है पंकज जी. और इसमें अपीलेंट नंबर 1 का डेट हुआ एंड आईए फॉर लिमिटेशन है ना, इसका नंबर है 2470 ऑफ 2022. सब्स्टिट्यूशन पिटिशन है 4839 ऑफ 2022. कनेक्टेड सीएमपी में इन्होंने सर्टिफाइड कॉपी फाइल किया हुआ है. ऑथेंटिकेशन फी भी फाइल किया है. ऑफिस सेम एकदम एवरीथिंग इज द सेम. डेट भी सेम.
Okay.
इसमें कोई प्राइवेट रिस्पोंडेंट तो नहीं है निकुल जी?
Item 3, first appeal filing number 8903 of 2024.
Where is the applicant? ये ऑर्डर्स में है. ये पेंडिंग है इसमें.
एक आईए 1207
FA number 8903 of 2024. Nobody appears on behalf of the applicant. IA number 1207 of 25 was taken up by this court. On 12/2/25, and through this IA, the appellant had paid for time to remove the defects. For extension of time to remove the defects. And on that day, it was submitted that the applicant had applied for certified copy of the award, but the same has not yet been received. A copy of order dated 12/2/25 was forwarded to the court concerned, and a letter number 23 dated 19/2/25 has been received, stating that award could not be prepared by the office due to transfer of the site of the PO. It appears that the appellant is not able to file the certified copy of the included award, as the same has not been prepared. Post this case on 30th of April 2025. Let this, and in the meantime, it is expected that the award will be paid by the concerned board. That a copy of this order be communicated to the concerned. Prepared and certified copy will be issued.
Item 4, first appeal file number 108983 of 2024.
Filing number first appeal 10983. By the order dated 19/2/25, office was directed to do the needful and send certified copy of the included order for necessary correction to the learned court concerned. As per the office note, the certified copy of the included order was sent through registered post. But the same has not yet been received back. There are other surviving defects which are to be removed. Post this case on second of May 25. Office is directed to send a reminder to the court concerned to send back the corrected certified copy of the impugned judgment. In the meantime, it will be open to the applicant to remove the other defects as pointed out by the office.
For hearing under order 41 rule 11 item 5, second appeal 39 of 2022.
Please, Bharat. On the last date of hearing, we had entered appearance as the new advocates for the appellant in this matter. Your Lordship, may I take your Lordship straight to page 13 of the petition, and that is the impugned order which contains the genealogical table, because I have been informed that there is no supplementary affidavit that has been filed with regard to any of the documents of the learned trial court. So this genealogical table, my lord, becomes extremely important to determine the substantial question of law, because we are on a second appeal, my lord.
At this stage of framing substantial question of law, we
Yes.
do not entertain any petitions.
Yes.
Nor do we fall for it.
I completely bow.
So you have to.
I just wanted to point out, my lord, I am not, I still believe that, my lord, there is scope of adding few more important questions of law which has been already there in the petition. Apart from that, there are certain important substantial questions which arise with regard to section 15, subsection 2 of the Hindu Succession Act. Because, my lord, in the genealogical table alone, I will try to explain the facts of the case briefly, and your lordship would understand that how this entire dispute has started. Now, my lord, may I have page 13 for a moment.
There are concurrent findings.
There are concurrent findings, yes, my lord. But
We'll come.
yes, my lord.
First, let us see the case of the respective parties.
Yes, sir.
Then we will see the case, what is the findings of the court.
Yes, sir.
And then we will see whatever you want to see.
Yes, your lordship. Your lordship, that is what I'll take your lordship to the findings of the court as well as the arguments that were advanced by the respective parties. But before that, my lord, just
Do it
in
in
a
your
gist,
own way.
yeah, in a gist, my lord, it would be easy to understand.
Okay.
Exactly, because for me also to just simply go through the impugned judgment was not a very easy exercise. The moment I understood the genealogical table,
So
the
let's.
facts became much more easier, my lord.
Okay. Thank you.
My lord, Schedule B is the genealogical table. Kumar Sahu is the main ancestor, my lord. He died in the year 1959. He gets allotted a particular plot by Tata Steel as a sublessee. Now, my lord, he married Jagoti Devi, and from Jagoti Devi and Kumar Sahu's wedlock, there were 3 daughters that were born: Ram Dulari Devi, Shyam Pyari Devi, and Shiv Devi, alias the plaintiff, my lord. The earlier plaintiff, she died, and thereafter the sons were substituted as the parties in the petition, my lord. Now, there was an allegation
What
that
about Shyam Pyari Devi? She's a party to the proceedings.
Shyam Pyari Devi is party to the proceedings,
And
my lord.
she had to.
Yes, my lord, this is the interesting part. So, Manvati Sahu, my lord, she was allegedly, I would not use that word, my lord, because the learned first
But
appellate
not
court-
a legally wedded
Yes,
wife.
not a legally wedded wife, my lord, but at the same time, she was cohabiting with the erstwhile ancestor Kumar Sahu.
Kumar Sahu.
Yes, my lord.
Any issue?
No issue from Manvati Sahu, my lord.
She was a party.
She was not a party, my lord. She died before the filing of the case. But what happens thereafter, my lord, that is interesting. The second daughter from Kumar Sahu and Jagati Devi, that is Shyam Pyari Devi,
Yes.
she has 2 sons. One is Bhikari Sahu and one is Shankar Lal Sahu. Now in 1981, my lord, that is after almost 30 or more than 30 years of the death of Kumar Sahu, and after 1962, my lord, this particular plot, Manvati Sahu gets the lease transferred. So this is the Tisco sublease property, my lord, and the
Manvati Sahu got the lease
lease transferred in her name. Now, what happened in 1962? That we are not concerned, my lord, because we are on a more important, substantial question that would arise from here. Now, what
Tisco
happens?
is a party.
Sorry, my lord.
Neither Tisco is a party,
Tisco is not a party.
nor Manvati Sahu is a party.
Manvati Sahu is no more, my lord. She is no more.
Oh,
She
that's
adopts.
fine. Any legal here.
Yes, my lord. That is what I am coming into. She adopts in 1981 Shankar Lal Sahu as her son. So basically,
1981. Shankar Lal Sahu as a
who is the son of Shyam Pyari Devi?
So he is in dual capacity.
Yes, my lord. So this is in a gist.
Did she adopt?
There is no registered adoption deed, my lord. The adoption is also
Did
illegal
she adopt prior to death of Kumar Sahu or after?
after the death of Kumar Sahu, my lord. And
Right.
in fact, when Shankar Lal Sahu,
So Shankar Lal Sahu cannot have a status of a family member by virtue of this.
no, the adoption deed is vitiated by Section 10 of the Hindu
We
Adoption
don't
Act.
bother about it.
Yes,
Since she is not a legally married wife,
yes,
therefore, any adoption in which Kumar Sahu had not participated
no matter
will not
whether
give the status of son.
no matter the question with regard to the legally wedded wife or not, that question was, although we had alleged that she is a concubine, I'm sorry for using this word, but my lord, that allegation has been negated by the first appellate court for the fact that Manvati Sahu and Kumar Sahu cohabited as husband and wife. Now, my lord, there are judicial precedences on this aspect. if a woman cohabits with a man, she cannot be termed as a concubine as far as the Hindu Marriage Act is
Whatever
concerned.
be her status, but her status, she cannot acquire the status of the wife.
Yes, my lord. But my lord, there is a rider to this. If there is a child that is born from that relationship, then that child would acquire the right to succeed
That's right.
in the properties of the ancestor,
That's right.
common ancestor.
Illegitimate.
Yes. So that child will have the right. So now what happened was, by dint of this adoption deed, Shankar Lal Sahu claimed that since Manvati Sahu had transferred
This
lease-
adoption deed has been exhibited.
no, this was not exhibited. Ma'am. The initial claim
See,
was,
if it was not exhibited,
Yes, ma'am.
then the very basis of claim of Shankar Sahu, being the
Yes, ma'am.
adopted son of Manvati Sahu, which she claimed was through a registered doctor,
exactly.
is not true.
Yes, my lord. So I'm glad, my lord, I'm able to, because my lord is with me on this. This was exactly my argument, my
We
lord.
are always with
Or
God.
this
Not
would
with
have,
you.
yes, my lord. This would have exactly been my argument in the if I had proceeded
You are
further.
for the
I'm for the appellant, my lord. I'm for Shiv
Appealant
Shiv
plaintiff.
Devi's son, Shiv Shankar Prasad, my lord. He is the son of
Shankar
Shiv
Prasad.
Shiv Shankar Singh. That is the appellant.
Shankar Singh.
Shiv
Who is
Shankar
son of-
Singh,
son of-
Shiv Devi, the third daughter.
Shiv Dev.
Who is the
The
original
plaintiff.
plaintiff? Original plaintiff, my lord. She is died
So
now.
you are representing the plaintiff.
Yes, yes, my lord. Yes. Now, my lord, what the first appellate court goes on to decide? This becomes important, my lord. Discarding a very important piece of evidence, which was of PW6, that is an official of Tata Steel, who goes on to record that this particular property was initially allotted to Kumar Sahu, and subsequently the lease was transferred to Manvati Sahu. In spite of that, my lord, the learned first appellate court goes on to decide that both Shiv Shankar Singh, that is the appellant before this honorable court, and the adopted son of Manvati Sahu, that is Shankar Lal Sahu, they both do not have title.
You see, once the lease deed was never challenged.
Lease deed was never challenged, my lord.
So therefore,
No, my
the
lord.
status of the property is that Manvati Sahu is a lessee to Tata Steel
Yes, my lord.
directly.
Yes, my lord. But, my lord, when a woman dies intestate, that is where section 15, subsection 2 would hit. That is the substantial question of law, my lord, which I was trying to point out at the very beginning, that has not been placed before this honorable court. And
If a woman dies intestate,
Yes, ma'am.
what is the consequence?
Consequences would be, my
She
lord,
would
depend.
not, you see, then what is the consequence?
May I take, my lord, to section 15 of the Hindu Succession Act for a moment?
Her son will not get a right.
But, my lord, if the woman acquires the property, depends from whom she acquires. If she acquires the property from her parents, then her father's, the family, they would be getting the right on the property. If she acquires the property from her husband, then the husband's family would be getting the right.
That's right.
And
But
in
she
this
is not,
case-
she is not acquiring the property from the husband.
My lord, this would come under the principle of acquisition because the original allottee was Kumar Sahu, and that I've got few judgments to support my case, my lord, on this.
Did she acquire the status of a lessee by virtue of the successor of Kumar Sahu?
Yes, ma'am. That is what is recorded in
that
the.
deed has been exhibited.
That has been exhibited, and that is what has been recorded. May I just point out for a moment before I take?
So therefore,
Yes, yes.
she acquires the status of the lessee,
Yes.
being the legal heir and successor of Kumar Sahu,
Yes, ma'am.
and that deed is not under challenge.
That deed.
Is not under challenge.
No, my lord, what happens is because
That admitted that deed is not
yes,
under
it has
challenge.
not been challenged. Ma'am.
That deed is not under challenge.
My lord, there is no deed. There is just a sublessee. What TISCO does is they issue a letter in which they simply transfer the lease by dint of.
That transfer is not under challenge.
Yes, that has not been challenged. That was in 1962. We are time barred, my lord. We cannot challenge that.
That transfer is not under
Yes,
challenge.
yes.
This was a partition suit.
This was a partition suit.
Then how does it acquire the status? How this property would be included in the joint family?
My lord, because Manvati Sahu gets his property from her husband. My lord, for a moment, your lordship may kindly have page 18, that is of the copy of the petition, which is a part of the impugned judgment. PW6, my lord, I will just read one paragraph and then I will take your lordship to Hindu Succession Act.
No, that is very clear. There is no doubt on that.
Yes, ma'am.
That if a female acquires property through her husband,
Yes.
then if she died intestate, the property will devolve upon the legal heirs
Yes,
of her
ma'am.
husband.
Exactly.
And if she acquires property from
Her
her
parents.
parents, then it will devolve upon the legal heirs of her successors from her parents'
From
side.
parents, side, yes.
But if there is a child, then it will devolve upon the child.
Yes, ma'am.
तो उसके लिए आपको उतना परेशान होने की कोई जरूरत नहीं.
So, madam, this is technically this is what that is why PW6 for a moment, madam, just may read that paragraph, and that would, close my arguments because this would show that the actual property that Manvati Sahu gets is from her husband. So when she dies intestate without leaving behind any children,
Now, how do you say that she died intestate? Because she adopts her.
no, my lord, that adoption becomes questionable because that adoption happens in 1981 when the respondent number 2 has already acquired, is already at the age of 21. Section 10 of the Hindu Adoption and Maintenance Act hits in, my lord, because Section 10 clearly bars that no
It's a
adoption.
registered adoption.
No, it is not a registered adoption. So, my lord, this number
Adoption
one.
has been proved.
No, it has not been proved. They have not.
Adoption has
It
been
was.
disbelieved.
It was all throughout ex parte, my lord.
Any issue framed on adoption?
No issues were framed. So, my lord, there is no question of that adoption be coming against me or coming or playing against me, my lord. PW6, my lord. I'll just read this paragraph, my lord. Who is a formal witness, and he is a circle officer in Tata Steel. He deposed that head land Tata Steel has sent him to depose on behalf of the company. The company has also produced the allotment letter number so and so, dated 21/8/1962, which is related to holding number 417 Kashidi Basti in the name of Manvati's wife of late Kumar Sahu. The document is 30 years old, so it may be marked as Exhibit 7. He further deposed that earlier the same holding was allotted in the name of Kumar Sahu, and after his death, the same is allotted to his widow. So, my lord, now this becomes extremely clear that the first appellate court was aware of this fact that this property initially was adopted in the name of Kumar Sahu.
Is there any finding that Manvati Sahu was not a legally wedded?
There is, my lord, the court actually goes on to discuss only on that aspect. May I take your lordship to the findings?
Now you just read
Yes.
the judgment in my name.
Yes, ma'am.
Correct? Let us see the trial court judgment.
Yes, ma'am. My lord would go to the trial court and then the first.
I always see the trial court
Yes.
first. Read paragraph 3.
Yes, ma'am.
Let us read the case of respective parties.
Just give me a moment. Let me just. Para 3, your lordship.
Para 2.
2.
Or you can read from para 1 itself.
Para
This
one.
partition suit.
This partition suit had been initially brought by Srimati Shiv Devi, alias Subhdeya, wife of late Durga Singh, after whose death her son and daughter, namely Shiv Shankar Singh and Srimati Saraswati Devi, stepped into her shoes. The said suit has been brought against the defendants Bikari Sahu and Shankar Lal Sahu, both the sons of late Mani Lal Sahu, who did not appear in the case despite all efforts, and consequently this case proceeded ex parte against them. As per the plaintiff's case in brief is that the superstructures within holding number so and so, Kashidi PO and POPS Sakchi, District East Singhbhum, more fully described in Schedule A of the plaint, is the subject matter of the suit. The different relations between the parties is annexed in the genealogical table as Schedule B of the plaint. It has further been submitted that the land measuring 40 feet by 40 within holding number so and so was allotted to Kumar Sahu by Tisco Limited, and he constructed Khapra Posh House and other structures over the said land out of his own earnings and lived peacefully with his family and paid regular rent and other charges to Tisco Limited. The said Kumar Sahu died sometime in the year 1959, leaving behind his 3 daughters, namely his legally married wife, Jagati Devi, vis-a-vis Ram Dulari Devi, Shyam Pyari Devi, Shiv Devi, alias Subhdeya. Among them, Ram Dulari Devi died leaving behind one daughter, Keshar Sahu, and said Keshar Sahu died issueless. Furthermore, Shyam Pyari Devi died leaving behind the defendants as legal heirs and successors, and the plaintiff Shiv Devi was alive. It has further been averred that defendant number 2, Shankar Lal Sahu, by committing some forgery in the documents without knowledge and consent of the plaintiff, got his name inserted in the records of Tata Steel, Limited with respect to the suit property and started paying rent and other charges in respect of the suit land in his name and started making claim over the suit property on such basis. It is further submitted that the defendant number 2 claim himself as adopted son of Manmati Sahu, who is a concubine of Umar Sahu, and she has no issue through him. But the suit holding was illegally transferred in the name of Manmati Sahu with a letter number so and so dated 21/8/1962 by Tisco Limited, and she started paying regular rent to the Tisco Limited. Defendant number 2 claiming himself as adopted son of Manmati Sahu and subsequently got his name transferred in the record of Tata Tisco Limited. With respect to the suit property and in an attempt to evict the plaintiff from the suit property, filed eviction suit number 07 of 2008 against the original plaintiff pending in the court of Munsif Jamshedpur. It has further been submitted that submission of defendant number 2 in GR case number 2259 of 02 in the court of so and so Jamshedpur conveys his admission regarding being not the owner of the suit property. So the plaintiffs are not the tenants. Rather, plaintiff's mother, the original plaintiff, was the co-sharer of the defendants, and her share comes out to be 50% of the share of the suit property of an area 800 square feet of the total area of 1600 square feet, along with other housing structures over the same. He has further submitted that suit property was never acquired either by Manmati Sahu or by the defendant number 2, and it was the exclusive property of Umar Sahu, who has constructed Khapra Posh House and other structures after its allotment by Tisco Limited, and it cannot be devolved upon defendant number 2 anyhow after the death of Manmati Sahu, who was the concubine of Umar Sahu. Accordingly, the suit property is a joint property of the plaintiffs and defendants, and the same has not been partitioned by metes and bounds. Plaintiffs requests that the defendant requested the defendant several times for such, but due to the forgery of records of the defendant number 2, avoided the partition and rather treated the plaintiff's mother as his tenant. On 7/12/2007 at about 11 a.m., defendant number 2 and his sons Mohit Sahu, alias Pappu Sahu, and his other associates came to the plaintiff's house and removed roof tiles of the plaintiff's house in order to forcibly and illegally evict the plaintiff. On protest of the plaintiffs, they threatened to kill them. They also assaulted, abused, and threw away household articles for which the original plaintiff filed a case under section 323, 341, 379, 427, and 34 of the IPC against the defendant number 2, his son, and others, bearing case number C11985 of 2007, pending in the court of Shri A.K. Tiwari, Judicial Magistrate, First Class, Jamshedpur. As the defendant number 2 got his name transferred illegally in the record of Tisco Limited in respect of the suit property, the defendants refused to partition the suit land lastly on 16/11/2009. Under the perpetual threat of the defendants over the peaceful enjoyment of the suit property by the plaintiffs, the suit has been
You
brought.
just tell us.
Yes, madam.
You say that the property should have devolved
Yes.
on the husband of the wife, on the husband if she dies intestate.
No, madam. So if the husband has predeceased the wife and the wife dies intestate, then the property by dint of section 15 of the Hindu Succession Act would devolve upon the husband if the said
The point
property.
is
Yes, ma'am.
that the property stood, the lease stood transferred in favor of Manvi.
Yes, sir.
If she has committed any fraud, or if she has committed any illegality, or if Tisco has committed any illegality,
Right.
then under such circumstances, the particular document of transfer cannot be simply ignored unless it is challenged.
Yes.
On the one hand, you say that she was not the wife of Mantu
Umar Sahu. Umar Sahu.
Umar Sahu. And on the other hand, you want to refer to Hindu Succession Act to give her the status of wife, and you want that the property should be subject matter.
Yes, sir. That is a difficult.
How is it possible?
That is a catch-22 situation, madam, that I am in
You
right
can't
now.
have it both ways.
I agree. I completely bow down to the observation, and
Unless, therefore, the status of Manvati Sahu was required to be declared.
Yes.
Unless you question that,
Well,
you cannot have this unless that particular status of Manvati Sahu is declared that she was
Madam,
not
but-
the legally wedded wife.
Agreed, my lord. But then at the same time, my lord, since this was a partition suit,
You are the plaintiff.
yes, yes,
You claim that she was not the legally wedded
legally
wife.
wedded wife. My lord.
And at the same time, the lease is not under challenge.
My lord, but the lease, even if today it has not been challenged, the fact that Manvati Sahu
It
died
will not
interstate,
become void ab initio.
my lord, but at the same time, my lord, this
No,
would give
because
rise
she
to a,
has she or her son or whatever had a right to address as to whether what was her legal status.
but my lord, since today, then this property would go into estate because then the government
We
would
do not know what will go. That
Because
particular, you cannot have it both ways.
Yes, Your Lordship. My lord, then my arguments is confined to section 15 and section 10 of the.
Section 15 will not come into play because it is your case that she was not the legally wedded wife. Then how the succession would come?
My lord,
Unless that document is set.
my lord, because today, even if considering for the fact that Manvati Sahu got it transferred by playing forgery or any illegal X number of illegal acts that might have been done, and she was not the legally wedded wife of Kumar Sahu. But the fact remains, my lord, that the property that she got in 1962 was from Kumar Sahu. That fact cannot be denied.
No, even if you see, there are numerous ways in which a person can get property. Right? So we do not know what
No, this
transpired
was-
unless that particular document. You can't say at the same time that she was a concubine and then you say that the property was transferred, giving her the status of wife, and therefore section 15 of the Succession Act would come into play unless you get it cancelled. Get it cancelled. You see, a property having been transferred in her name in the year 1962,
Yes.
and if you don't have any knowledge about that, you could have still challenged it. But you don't take that step.
I was a child, my lord, that time, so it was.
But you have not challenged it.
Yes. Yes.
And unless that particular document is set aside.
But the statement of PW6 and the Exhibit 7, then that comes into my rescue because PW6.
So your case that she was a concubine remained undisputed.
No matter that issue has been addressed by the first appellate court. The first appellate court only on the point that she was not a concubine gives a finding, and therefore the court comes out with the ratio that none of the parties, that is the appellant or the defendants, none of the parties have any right, title, or interest over the suit property. So that is where the problem is. That is where the error on the face of the judgment, my lord, which I was trying to point out, because the Honorable First Appellate Court did not consider these vital aspects such as the statement of PW6 and the Exhibit P7. When the property, in fact, my lord, since that document is not before your lordship, so I cannot rely to that document at this stage. But may I just spell out what was written in that Exhibit 7? That clearly mentions that the property which was earlier allotted to Mr. Kumar Sahu and is now being re-allotted as sublessee to Manvati Sahu, wife of late Kumar Sahu. That is what that particular lease transfer records. So, my lord, that issue can only be determined once this appeal is admitted. And once, my lord, this court comes out with the finding, what happens in a case when there is this kind of a situation that arises. So this gives rise to a very important substantial question of law, my lord, which needs to be determined. At least, my lord, from what research I have done, in cases where I would again go back and forth, my lord, I do not want to get very repetitive with my arguments. But this would definitely fall under section 15. That is what my understanding goes, my lord.
What is the finding of the learned appellate?
First appellate court, my lord.
Appellate court has given a finding that she was the wife.
She has. That's it. There is no further finding given. May I just read the findings, my lord? I would read, my lord, after the PW6 statement, page 18 from the bottom, because the first part of the finding is only about the witness statements that the first appellate court has recorded. May I read the last paragraph, page 18, my lord?
Yes.
First of all, I would like to emphasize the memo of appeal which is filed by the appellant, in which they have asserted that Kumar Sahu died in the year 1959, leaving behind his two wives, vis-a-vis Jagati Devi, legally married wife, and Manvati Sahu, concubine. which is beyond the pleadings of the appellant, which is filed by them in the lower court, in which they have clearly mentioned that Srimati Manvati Sahu was concubine of Kumar Sahu. Concubine doesn't come within the purview of wife. A concubine is a wife without title. When a man and a woman live permanently as a husband and wife without the benefit of the marriage, the woman gets the status of concubine. Although a concubine serves the functions of a legal wife, she doesn't enjoy the rights in a family or any spiritual comforts. In a case of Indra Sharma versus VKV Sharma in criminal appeal number so and so. Yes, madam. So then the learned first appellate court goes on to discuss the judgment.
All the witnesses.
Sorry, madam.
Now all the witnesses claimed.
All the witnesses. I'm sorry, madam.
Next page.
Next
Page 20
page.
bottom.
All the witnesses have claimed that defendant number 2 was illegally entering his name in Tata Steel Company as sublessee, and he claims as absolute owner of the suit property. Initially, they have filed civil partition appeal number so and so, in which they have amicably settled their dispute. During the pendency of the said appeal, appellant number 1 has deposed that they have compromised the case, and the compromise petition is marked as Exhibit 1. He will get Schedule A property of the compromise petition. Appellant number 2, who is witness number 2, has also stated the same thing. Respondent number 1, who has also given this statement as witness number 1, that they have compromised the case, he has also signed on the compromise petition, which is marked as Exhibit A. He further deposed that they will get Schedule B property as their share, which is mentioned in compromise petition. Respondent number 2, who also gave statement in the same thing as witness number 1. Here, one thing has arisen whether parties are competent to compromise the case or not. The appellants have asserted in their plaint as well as memo of appeal that defendant number 2 has made some forgery of the documents without the knowledge and consent of their mother, and thereby got his name transferred in the records of Tata Steel Limited, Jamshedpur, in respect of the suit land. But they have neither filed any document before the lower court nor before the appellate court. So the parties are not competent to compromise the case because they have got no right title over the said land. As this case proceeded ex parte, there is not any iota of evidence from the side of the defendants. Exhibit 7 shows the lease of the land over the suit property, which is allotted in the name of Mrs. Manvati, wife of late Kumar Sahu, who has been figured as concubine by the appellants/plaintiffs, and the very genealogical table filed by the plaintiff as Schedule B in their plate. They have no relation with Manvati Devi, whereby the very claim over the suit property by the plaintiffs falls flat. It should be false, madam. As per genealogical table, the plaintiffs are descendants of Jagati Devi, who is legally married wife of Kumar Sahu. Exhibit 6, 6 by A and 6 by B are the private documents which have got no sanctity and are useless in this case. On perusal of Exhibit 1, it appears that the defendant number 2 has deposed in a criminal case that he has got no right over the suit property. As per the documents produced by the appellants, the version of the defendant number 2 is quite correct. The appellants have also failed to produce the documents which shows that the defendants number 2, claiming to be the adopted son of Manvati Sahu, there is no link with Manvati Sahu, who is favored that Disco has allotted the land on monthly tenancy. The appellants have no right to claim partition of the suit property. Hence, I find and hold that there is no relationship in between leaseholder and the parties to the appeal. Thus, the appellants are not entitled to get 50% of the said share from the suit land. So,
What is the story of this compromise?
sorry,
What is
compromise, my lord, what I have been informed that these parties amicably wanted to settle it. They filed a compromise petition. However, my lord, due to error in the filing, due to the pecuniary jurisdiction, my lord, they had to withdraw that particular case. And
Where do I get this?
my lord, I would have to seek instructions with this compromise because my lord, nothing is there in record in the before this honorable court as on date. Since, my lord, there is a compromise, there is a very good judgment of the Honorable Supreme Court dated 1980 by Justice Krishna Iyer, which says that in a similar situation where a stepmother is there, I'm using the word stepmother, that looks more parliamentary, my lord, because that I would not use that word. So, a similar situation had arisen wherein there was a lacunae which was observed by the Supreme Court, but the parties went into a compromise. And the Honorable Supreme Court allowed that compromise because the parties wanted to amicably settle the dispute. And that was a long-standing dispute like this, the instant case, my lord.
Okay, second appeal number 39 of 2022. Your name, please.
Chayan Sarkar. CHAYAN.
Please give me
Yes.
writing. Both of you. This appeal has been filed against the judgment dated 31/3/2022, within bracket decree dated 8/4/2022, that is passed by the 4th District Judge East Singh Jamshedpur in civil within bracket partition, that is appeal number 27 of 2020, whereby the judgment and decree dated 19/7/2012, within bracket decree signed on 2/8/2012, that was passed by the Civil Judge Senior Division Roman 6, Jamshedpur, in original partition suit number 150 of 2009 has been confirmed, and ultimately the suit has been dismissed. The appellant, the plaintiff is the appellant before this court. The learned counsel for the appellant has submitted that the suit was filed seeking partition of a property which originally stood in the name of Kumar Sahu as a lessee under Tata Steel Limited, and further stood transferred in the name of Manvati Sahu, who was a concubine, bracketing, as Kumar Sahu had a relationship with Manvati Devi during the lifetime of his wife, namely Jagoti Devi. He has submitted that in the lease, Manvati Sahu showed herself in the document regarding transfer of property in name of Manvati Sahu after death of Kumar Sahu in the year 1959. It was mentioned that Manvati Sahu got that property as in the capacity of widow of Kumar Sahu. The learned counsel has further submitted that no child was born from the relationship between Kumar Sahu and Manvati Sahu. And so far as the wife of Kumar Sahu, namely Jagoti Devi, is concerned, she had 3 children, 3 daughters. There was ultimately no legal heirs and surviving legal heirs and successor of the first daughter, namely Ram Dulari Devi. So far as second daughter, namely Shyam Pyari Devi, is concerned, she had 2 sons, Bhikhari Sahu and Shankar Lal Sahu, dependent number 1 and who were dependent number 1 and 2 respectively. And Manvati Sahu died in the year 1996, and Shankar Lal Sahu, dependent number 2, was claiming the entire property by stating that he was the adopted son of Manvati Sahu. The property was transferred in his name?
In
Name of Shankar Lal Sahu?
Shankar Lal Sahu, my lord, yes. He
Yes.
got the sublease transferred in
And
2009.
and he got the sublease transferred in his name in the year 2009 in the capacity of son of Manvati Sahu. The learned counsel submits that the suit was decided ex parte as the defendants did not appear and contest the suit. He has further submitted that since Manvati Sahu had declared herself to be the wife of Kumar Sahu at the time of transfer of the property in her name, transfer of the lease in her name, and therefore the property should have devolved back to the legal heirs and successors, other legal heirs and successors of Kumar Sahu through Jagriti Devi, as Manvati Sahu had no child from Kuvar Sahu. He submits that in that circumstances, an important question of law arises for consideration in this case and refers to section 15
Of the Hindu
of
succession.
Hindu Succession Act, and has submitted that if the wife dies intestate and had some property in her name in the capacity of the widow, in the capacity of widow of a Hindu family, then under such circumstances the property would devolve back
The source, madam.
to the source, that is to the legal heirs and successors of the husband. He submits that this aspect of the matter, though not raised before the learned court, but is a point of law which arises for consideration, and the second appeal be admitted by referring to section 15 of the Hindu Succession Act, and the records we call for and notices we give to the participants. After hearing the learned counsel appearing on behalf of the appellant, this court finds that the specific case of the plaintiff seeking partition of the suit property, which stood initially allotted to Kuvar Sahu by Tisco, who died in the year 1959, was that Manvati Devi was a concubine and accordingly was not the legally wedded wife of Kuvar Sahu. This court finds that admittedly the lease stood transferred in name of Manvati Sahu, though showing herself to be widow of Kuvar Sahu, which happened way back in the year 1962, and subsequently Shankar Lal Sahu, who is descendant of Kuvar Sahu through Jagriti Devi, but it stood transferred exclusively in his name, showing that he was the adopted son of Manvati Sahu. This happened in the year 1969.
Madam, the year I will have to confirm.
Okay,
I'll just-
anyways, we'll see that. This court finds that the transfer of lease in favor of Manvati Sahu and then to Shankar Lal Sahu by Tisco has not been under challenge in any proceedings. Who was in possession of the property?
Madam, it was the plaintiff who was in, they were in joint possession, and that is what the contents of the plaintiff is.
Was never challenged, and this court finds that the learned trial court framed as many as 4 issues, including issue number 3 as to whether the plaintiff is entitled for partition over the suit premises. And after considering the materials on record, the learned trial court decided that Exhibit 7 showed that the lease of the land over the suit property was allotted in favor of Mrs. Manvati, wife of late Kuvar Sahu, who has been branded concubine by the plaintiff. And it was the specific case of the plaintiff that they have no relationship with Manvati Devi. This court is of the view that once it was the specific case of the plaintiff that Manvati Devi was a concubine, there was and the transfer of property in favor of Manvati Devi through Exhibit 7 was never challenged by the plaintiff. The same cannot be subject matter of partition, and consequently the learned trial court has rightly held that as per the plaintiffs, they have no relationship with Manvati Devi, whereby and consequently the very claim over the suit property by the plaintiffs was not sustained. The appellate court has also considered the materials on record and has given the genealogical table in the impugned judgment and has framed the point of determination in paragraph 10 as follows. The learned appellate court has observed that in the memo of appeal filed by the appellant, they had asserted that Kuwar Sahu died in the year 1959, leaving behind his two wives, Jagrati Devi, legally married wife, and Manvati Sahu, concubine. And the appellate court observed that the said finding was beyond the pleadings of the appellant, which was filed by them before the trial court, in which they had mentioned that Srimati Manvati Sahu was concubine of Kuwar Sahu. And that concubine does not come within the purview of meaning of wife. The learned appellate court ultimately held that it was the case of the plaintiff that they had no relationship with Manvati Devi. And therefore ultimately held the plaintiff had no right to seek partition and claim 50% from the share of the suit land. This court is of the view that
May just point out, sorry. The first appellate court also considered the compromise petition and said that the defendants also don't have any right title to this.
we are not concerned
Yes.
with that. It is only partition.
Just wanted to point that out.
This court finds that in a case where the proceeding was ex parte and it was a specific case of the plaintiff that Manvati Sahu was a concubine, and ultimately the property stood transferred in the name of Manvati Sahu by Disco by a document, and the same was never under challenged. The learned court has rightly considered the case of the plaintiff, specific case of the plaintiff, wherein they stated that there was no relationship with Manjati Devi and has rightly dismissed the petition seeking partition over this matter. This court finds that in such circumstances, the argument of the learned counsel for the applicant referring to section 15 of Hindu Succession Act will have no role to play once the case of the plaintiff was that they had no relationship with Manjati Devi and they had termed her as one.
But you may just refer to one judgment, and that would be it, madam. Because that,
Not after arguments, I have heard you.
yes, madam, I agree. Just
After
one.
the dictation of the judgment, you can't refer to any.
No, because my lord, I was hoping that I would get a chance, but nevertheless, my lord, there is this judgment of the Honorable Supreme Court which states that when there is an interstate death of the wife, and if she has acquired the property, what I have already stated before, but the intent of section 15 that is brought out in this judgment, and the intent was that the property does not go into any third party, and the intent was that the property must go back to the source.
Council has, but they
Yes, ma'am. I just
has referred to judgment passed by the Honorable Supreme Court reported in
my lord, it's S.R. Srinivas and others versus P. Padma Vathamma, 2010, 5 SCC,
2010
5 SCC,
5 SCC
274.
274. Page number, please.
Page, my lord, is
Para number you can refer to
para 34.
Para 30. You have got
I
that
just
judgment.
pass on that particular paragraph.
Para. You give me the judgment. You have got the copy of the judgment.
I was carrying a compilation, my lord, but
Para 34. You submit ऊपर ही लिखे हैं ना para 34 बैंक का submission. This court is of the considered view that the appellant seeking partition, having taken a specific stand that Manjati Devi was a concubine and had no relationship with the plaintiffs, cannot be permitted to argue that she was the widow and accordingly the widow of Kuvar Sahu, and accordingly the property would not devolve upon the other legal heirs and successors of Manjati Sahu. The fact remains that Shankar Lal Sahu is certainly one of the legal heirs and successors of
yes, ma'am. Okay, sorry, I got not Manjati. Sorry, yes,
not through Manjati
yes,
Sahu.
yes. I thought my lord would be.
He is certainly one of the legal
Yes, yes, that's true. From the second daughter, he is
Whatever
son,
be the-
yes, yes.
A genealogical table.
There is no denial
It's
between
for
the
extract.
parties.
Page number 3.
There is no denial as far as that.
You have to wait for the certified copy.
Very well, my lord.
You have your patience.
I'm so grateful, my lord.
But you have argued very well.
Thank you, my lord. There are times, my lord, in second appeal and further, where due to some mistakes in the trial court, our hands are tied, my lord. That's
But we can't help it. That
yes,
is
my lord.
the
That's all.
process of
Yes,
law.
my lord. I'm
We
grateful.
really
my lord.
can't do it. My concern is that you can't have it both ways.
Yes, I agree.
You can't tell her a concubine and then simultaneously claim that she is the widow merely because in the lease deed it is mentioned.
Yes, my lord. Grateful, my lord.
What is
It's a traditional matter of using it. We have to dismiss for default or non-compliance with the order of surrender certificate. Now the appellant
when will you surrender?
I have already surrendered and filed the Vakalata of the jail.
Step 22.
Which is CRMP number 451 of 2020.
Individual. But just to point out, we have also filed one CRMP earlier for the same restoration of the criminal division, and Mayock sir pleased to order to remove the defect of the criminal division, that is the limitation petition and type copy of certain pages. But on time, we could not able to file that, and ultimately the revision has been stand dismissed. And thereafter, we filed this again CRMP application. We undertake that within a day.
Second CRMP restoration. It is a petition seeking restoration of restoration.
No, it's restoration of
How-
main division application.
How the second will be maintained?
Because first revision of first CRMP application it was allowed to the extent to remove the defect, but I could not able to remove the defect. That is the I application and limitation application. And
Second restoration application is not satisfies.
Restoration of because the
Once
CRMP
the restoration application is dismissed,
disposed of. Yes, ma'am.
once the restoration application was disposed of, stating that you remove the defects within certain time,
Correct.
and you don't remove that defect
Correct.
within that time,
Indeed.
and it's too dismissed, then what is
But-
the remedy for you?
But the revision was never restored.
So you will file another application for
Because
restoration.
I could not file CRMP application of the first CRMP application because the CRMP application is not dismissed for default. The CRMP application
You could have filed a petition seeking extension of
No.
time.
That was should have done.
देखिए प्रोसीजरल एरर मत कराइए आप क्रिमिनल मैटर्स भाई अगर मान लीजिए आपको 15 दिन दिए डिफेक्ट रिमूव करने के लिए यू कुड हैव सेड
My second page is also there with the CRMP application with the to further please enough to modify the order dated 2011 to 24 past due CRMP number 2697. ये दोनों हम करते हैं. That is page 3.
देखिए सीआरएमपी नंबर 251 of 2025 the learned counsel for the applicant petitioner has submitted that the criminal revision number 1316 of 23 was dismissed on account of non-removal of defect. Particularly the defect was relating to filing of surrender certificate.
Indeed.
He submits that a petition seeking restoration was filed, which was numbered as CRMP number 2697 of 2024, which itself was disposed of by order dated 22nd November 2024, wherein time granted in the revision to remove the defect was extended till 6/12/20. The learned counsel submits that the defect could not be removed, and consequently the present CRMP number 451 of 2025 has been filed. He has submitted that a prayer has also been made in this petition to extend the time allowed in CRMP number 2697 of 2020. He has submitted that in this case, Wakalatnama from jail has been filed. Where is the Wakalatnama?
It is in the record. Along with the first CRMP, in this CRMP we have also filed the Wakalatnama.
Has been filed, which is dated 13/2/2020. The learned counsel has submitted that 1 week.
1 week.
That was the only defect.
Wakalatnama, one limitation petition that is ready. The Parimkar has to
The
come.
learned counsel submits that 1 week from today would be sufficient to remove the surviving defects in the CRMP. आपको कोई objection है? The learned counsel for the respondent state has no serious objection to the prayer. Considering the aforesaid facts and circumstances, this court finds that considering the aforesaid facts and circumstances and the fact that Wakalatnama from jail has already been filed in the present CNP, it appears that the CRMP, it appears that the defect regarding surrender has already been
Already.
removed. Office is directed to place the वकालतनामा उसमें आपको फ्रेश फाइल करना
हम
यहाँ पे
fresh-
किससे है?
हम सीआरपी में भी फाइल किए हैं, तो डिवीजन में भी फाइल कर चुके
ये
हैं
डिवीजन में भी वकालतनामा फाइल कर दिए फ्रेश
तीन
फ्रॉम जेल
वकालत हाँ फ्रॉम जेल 3 वकालत हम इसमें फाइल
दूसरे केस से रिलेटेड तो नहीं है ये?
नहीं इस पे एक ही केसेस का बनता
He has, a council has also submitted that a wakalatnama from jail has also been filed in the criminal division
है इन द
petition office to check. Consequently, the time granted by order dated 22nd November 2024 in CRMP number 2697 of 2024 to remove the defects in criminal division number 1316 of 2023 is extended till 26th. If the defects are removed within time, office is directed to place this case before appropriate bench as per roster, if possible on 28th.
very much
Hearing. After taking due permission from the concerned.
From taking list of final disclosure item 4, second appeal 380 of 2017.
Plaintiff second appeal notes, admitted notes by order number 5, dated 22nd October 2019.
Order,
Order number 5,
order.
22nd October 2019.
Yes.
Yes. But the second appeal shall be heard on the following substantial question of law. First is whether the judgment of the learned court below is vitiated for not at all considering Exhibit 10, that is the order passed in compensation case number 14 of 1953-54, where the name of ancestor of the appellant plaintiff finds mentioned, whether the judgment of the appellate court below will survive in view of their judgment in AIR 1968 Patna, page 302 full bench, Udi Devi judgment. So these are two questions. But the case of the plaintiff is for declaration of right title of confirmation and recovery of possession. But the plaintiff's case is that the land, suit land, is a gair majurwa khas land.
You are the plaintiff.
Yes, I am the plaintiff.
No, continue.
Yes, but the land in suit land is gair majurwa khas land recorded in the name of Mahant Brahma Prakash Das. He is the ex-landlord, and Khatian is Exhibit 16. There is no dispute on this.
Just a minute.
Mahant Brahma Prakash Das.
Prakash Das.
Yes. He is the ex-landlord. Khatian is Exhibit 16.
Exhibit 16.
Yes. But he granted settlement by terms of a hukumnama. And the hukumnama is dated Chet Wadi 13th Sambat 1946 Sa. This is the date.
What is the corresponding English?
But if we take Sambat 1946, the corresponding would be minus 57. Because Sambat is not 9. But the word Sal is also written. Not, let us proceed, not then I will.
1946.
1946.
Any particular date?
So, no, there is no date. But the wording
1946.
1946.
Hukumnama is
1946. And this was, Hukumnama is Exhibit 11.
Exhibit.
11. it was granted in favor of Badamiya Devi of is Badamiya Passing. Because somewhere it is written
Badamiya.
Badamiya, Badamiya.
Devi.
Yes. Your Lordship may also record not passing also. Because
Passing,
judgment
P-A-S-I-N?
P-A-S-I. Correct. And she is wife of Bandhu Passing.
Bandhu.
Bandhu, Bandhu.
Pass.
Yes. But by this Hukumnama, she was granted two lands, that is of Khata number 21, lot number 106, area 5.44.
Khata number 21.
21, lot number 106, area 5.44 acres,
5.44 acres.
and Khata number 18,
18.
but there are 5-6 plots, area is 1.46 acres,
1.46.
total 6.90 acres.
This is the suit property.
No, suit property is only 5 acres of Khata number 21, plot 106.
Is it 5.44?
No, only 5.
Suit property.
Is only 5 of Khata number 21.
Five acres.
Yes,
Khata number
21, plot 106.
Khata number 106.
Yes. But this Hukumnama was followed by delivery of possession coupled with the rent receipt by the ex-landlord, that is Exhibit 2 series.
What is the date?
But 1951 currency,
1951.
prior to vesting. Ex-landlord का received prior to vesting, and notes
What
it
is
is
the
for
date of vesting?
1954-55 notes, somewhere between 1954. Sorry.
Date of vesting is October 1950.
No, कहीं वो कहीं 44, 51, sorry, 54, 55. So not. It is further case that
ऐसा नहीं होता.
yes.
There is a very, very crucial date. What is the finding with regard to date of vesting?
There is no finding with regard to date of vesting, and there is no dispute between the parties so far as date of vesting is concerned.
But zamindari rent receipt, you are
Yes.
relying upon zamindari rent receipt.
Yes.
Date of vesting is an important
But
aspect.
उसके बाद एक स्टेप और आगे जाए नोट अगर एक्स लैंडलॉर्ड जो रिटर्न फाइल
Return
दैट इज
क्या है?
कॉम्पनसेशन केस जिस पे एसेस हुआ इस पे एक्स लैंडलॉर्ड का रिटर्न पे अंडर द प्रोविजंस ऑफ बिहार लैंड रिफॉर्म्स एक्ट
Exhibit number.
exhibit 10 on that substantial question of law has been followed.
इसमें क्या दिया है?
बट इस पे दिया है कि ये इनके नाम पे पोजीशन में है क्योंकि उसमें तो नाम दिखाता है नोट प्लॉट नंबर दिखाता है कॉम्पनसेशन केस में कि किसके
Shown in
नाम
possession.
कुछ वो तो रिटर्न नोट
Return में.
रिटर्न में तो नाम दिखाता है एक कॉलम एक में दिखाता है कौन सा खाता कौन सा प्लॉट है कितना एरिया दिया तो वो फाइल करते हैं एक्स लैंडलॉर्ड बिफोर कलेक्टर दैट इज इन टर्म्स ऑफ नोट बीएलआर
That's right.
so नोट दैट इज एग्जिबिट 10
Exhibit 10. उसमें इस property का description
Yes,
is
yes, yes.
included.
हाँ it is included and after this note the further case is that the name was mutated and rent receipt was also granted by the state that is exhibit 1 series
Start up का date.
but that is from 55 so 56 onwards 56 57 58 जो है 80 का भी है तो rent receipt continuous by the state that is exhibit 1 series. Now notes it is further case of the plaintiff that in between the plaintiff's family there was a dispute and therefore a partition suit was filed by and between the family members. In that partition suit it was held कि suit dismissed हो गया by the other plaintiff and it was decided in favor of the defendant although not the defendant were not there in that
तो
partition
उसका
suit.
मतलब नहीं है. आप सीधे Exhibit 10 में.
Yes, notes हम नहीं इनका क्लेम बता रहे now notes the state settles
the
the land but they are not they are state and the settlers from state so state government जो है 1961-62 में सेटल कर दिए in favor of defendant number 3
The settlement is under challenge.
No, the settlement is not under challenge. Because notes, if my claim succeeds, my claim is vis-a-vis state. If state falls, not the settlee will definitely go out. And notes, defendant number 3 claims settlement in the year 1960-61 and 4, 5 and 6 उन लोग सबको एक एकड़ सेटल किए 86, 87.
5, 6, 7 तो एक एकड़ 3 और 4 को 2 एकड़
अच्छा 3 और 4
3 and 4 को 1961-62.
86, 86, 87.
नहीं 3 और 4 को 1960-61
But ये
केस नंबर 27
3, 4.
3, 4 not
1960,
60, 61 2 एकड़
61, 2 एकड़.
और 86, 87 में 5, 6, 7 को एक एकड़ ईच. इसीलिए 5 एकड़ का नोट शुरू. 2 और इधर एक एकड़.
I am representing only these two persons, two sets of persons.
5, 6, 7 को 1 एकड़.
1 एकड़ ईच. तो 5, 6, 7 नोट्स 3 एकड़ हो गया. 3, 4 में 2 एकड़.
ये
इसीलिए
दिए हैं इनको 1987.
86, 87.
86, 87 केस नंबर 27
27 of 86, 87 settlement.
27 और
86, 87.
86 एक ही केस नंबर से.
हाँ एक ही केस.
और 60, 61 का केस नंबर क्या है?
27 of 60, 61.
27 और
60, 61.
60, 60. दोनों का केस नंबर 27.
27. और साल आपका अलग है.
ठीक है.
But so therefore not the if state falls, definitely they will fall. So not my entire emphasis would be to show not what is my pleading and then what is the state's reply, and not it is very relevant that state have only produced one evidence and no documentary evidence by the state.
What is the sole evidence of the state?
Yes. State.
Quantity of evidence is already decided.
Quantity of
What is
evidence
the
is,
quality
but
of
because
evidence?
I am the plaintiff, so not
What is the quality of evidence there? What is that evidence then?
yes, I will. Evidence. So not let us proceed further. That how the
पहले state का बताइए. आपके पास हुक्मनामा है, followed by जमींदारी रेंट रिसीट है,
Yes.
followed by mutation.
नहीं followed by notes उसके बाद का compensation case,
हाँ, compensation case,
Yes.
mutation
mutation,
and possession.
rent receipt. Mutation मतलब rent receipt by state and possession. So
तो
ये
जिनको
notes
settle किया उनको possession नहीं मिला.
but इनका क्लेम है ये पोजीशन में, मेरा क्लेम है हम पोजीशन में है. हाँ लेकिन क्योंकि मेरा पोजीशन जो है at before vesting
Your prayer was confirmation of possession.
confirmation oblique recovery both. So not
स्टेट का कौन सा एविडेंस है जो आपका दोनों केस आपको आपके अगेंस्ट?
बट यहाँ पे मेरा जो केस है इसीलिए क्वेश्चन ऑफ लॉ है. एग्जिबिट 10 जो मोस्ट क्रूशियल डॉक्यूमेंट है क्योंकि
स्टेट का कौन सा एविडेंस है जिसको डिलाई करके आपके अगेंस्ट?
बट स्टेट का तो एविडेंस को ऐसा कोई रिलाई नहीं किया. इन लोग मेरे एग्जिबिट 10 जो
आप बोले स्टेट का एक
हम दिखाएंगे.
हाँ, बट दिखाइए ना. दिमाग अटक गया.
अच्छा
माइंड व्हेन गेट स्टक यू हैव टू क्लियर दैट माइंड, अदरवाइज द नॉन रिसेप्टिव हो जाएंगे. हम आपकी बात हमको
अच्छा नहीं बट ऐसा बात हुई है. हम दिखा रहे हैं डिफरेंट नंबर 1 और 2 का.
It is a very natural phenomenon. If mind gets stuck, you become non-receptive. बताइए कौन सा एग्जिबिट है, कौन सा ऐसा डॉक्यूमेंट है?
बट डॉक्यूमेंट तो है ही नहीं स्टेट की तरफ से.
स्टेट का कोई
स्टेट का कोई डॉक्यूमेंट
नो डॉक्यूमेंट्री,
नो डॉक्यूमेंट बाय स्टेट. इट इज ओनली वन एविडेंस गिवन बाय द स्टेट. वो बता
सरेंडर है.
चंद्रशेखर आजाद का नाम डिफरेंट.
क्या है बताइए, क्या एविडेंस?
बट हम उसको प्लेस करें बट तब तक हम ये दिखा रहे कि क्या है, क्या इश्यूज है. तब तक हम
इतना स्लो स्पीड में मत चलिए, आप बताइए क्या करना
Note by take notes running page 57, note where the trial court issues have been framed. But the most crucial issue is issue number 8. Whether the plaintiffs are entitled to right title, right interest and possession over the suit land on the basis of heirs of person whom Hukumnama was granted by the ex-landlord in summer 1946.
And what about issue number 4? It was decided in your favor or against?
Issue number 4.
Limitation, adverse possession,
But suit is filed within limitation, hence the suit is filed within limitation.
limitation का कोई issue नहीं है.
But कुछ ऐसा फाइंडिंग नहीं है, लेकिन कोर्ट का ये है.
विद इन लिमिटेशन हो गया, बात खत्म हो गया. क्योंकि अगर विद इन लिमिटेशन का फाइंडिंग नहीं है तो कोई क्वेश्चन ऑफ लॉ का क्या ही मतलब है.
हाँ, तो लिमिटेशन से बाहर है तो फिर नाउ ये
एंट्री
लॉजिक
टिकट ही नहीं है ना. बताइए. You claim to be the heir of the holder of the hukumnama.
But I claim to be the heir of the holder of the hukumnama, in whosever return was also filed.
You were the son.
But if your lordship may kindly note.
You were directly from the recorded this holder of the hukumnama, or you are a generation ahead.
But बेदमिया पासिन जो है वो बंधु पासिन की वाइफ हुई.
And you claim to be the son of Bandhu Pasin.
नहीं बंधु पासिन, वो बंधु पासिन के 3 और भाई थे. That has come and exhibit 8 is a judgment which says कि जो suit property जिसका suit फाइल हुआ था that belongs to this बेदमिया and these defendants. So that is a judgment between the parties which says कि क्योंकि internally जो है that has been held.
That will not bind them.
That will not bind them. But so far as my claim is concerned over the suit land, that will definitely and will not be.
That has got no bearing.
Yes.
आप
Not
दो
हमने
पार्टी मिलके पार्टीशन सूट में कोई एफिडेविट देके कुछ भी
नहीं मिलोट हम लोग फैमिली मेंबर्स ही है.
उससे कौन
नॉट जो प्लेंटिफ है और ये जिनको हुक्मनामा मिला वो लोग एक ही फैमिली से बिलोंग करते हैं. हाउ मिलोट दे विल शो बंधु पासी जो है.
आप अपने पिताजी का नाम बताइए.
हाँ लक्ष्मण.
लक्ष्मण.
हाँ बंधु मिलोट एक चीज नोट कर लीजिए.
You are only plaintiff or 2 plaintiffs?
2 प्लेंटिफ है. एक बेटा है बालकिशुन पासी जो है वो प्लेंटिफ है और महेंद्र जो प्लेंटिफ नंबर 2 है वो बालकिशुन का बेटा है. 1 and 2 are
Balkishun is
Balkishun is son of Lakshman.
Son of Lakshman.
And Mahinder Pasi is son of Balkishun.
No, who is the father of Lakshman?
But Lakshman और बंधु जो बेदमिया के जो हस्बैंड है वो आप ओन ब्रदर.
Lakshman is brother of
बंधु पासी जो कि बेदमिया जिनको हुक्मनामा से मिला उन लोग दोनों अपने भाई.
Bandhu Pasin. And property was in the name of Bedami.
हाँ वाइफ ऑफ बंधु और उनका कोई इशू नहीं. एंड
एक सेकेंड. बदामिया के डेथ के बाद
यस
how will the property devolve upon the brother of Bandhu?
बट बेदमिया जो है इट इज केस कि इनका ये बालकिशुन को वो बोथ वे ब्रदर्स बंधु और लक्ष्मण. एक मिनट. अब बेदमिया और जो लक्ष्मण की वाइफ है जिससे ये बालकिशुन आए दे वर आल्सो सिस्टर्स. लक्ष्मण की वाइफ हुई बंधिया और बंधु की वाइफ हुई बदमिया. ये दोनों अपनी बहन है और बंधु और लक्ष्मण अपने भाई.
Full brothers.
फुल ब्रदर्स एंड बेदमिया एंड बंधिया जो प्लेंटिफ की जो मदर हुई ये दोनों अपनी बहन.
Own sisters.
Yes. And therefore not by way of inheritance also we'll get this. and there is a judgment also under Exhibit 8, which is just informed the Lordship. In this way, it has been held by the court कि this property belongs to Bedamia and these defendants, जो लक्ष्मण से नीचे आए. Towards
अब सीधे substantial question.
yes, हाँ ठीक है.
You read the
Findings of the trial court.
read the defendant's case. आप यहाँ पे पहले पैरा नंबर 2 पढ़िए, ट्रायल कोर्ट पैरा 2 पढ़िए तो
Yes. The pleadings of the plaintiff in brief is that the land appertaining to Khata number 21, plot number 106 of other plots of village Pakaria, PS Chatra, district Chatra was Gair Mujudwa, khas land of the ex-landlord of village Pakaria recorded in last survey operation. Total area of plot number 106 is 5.44 acres. Mahant Bang Prakash Das was the ex-landlord of village Pakaria who by virtue of Hukumnama in Sambat 1946 settled 5.44 acres of land of plot number 106 and 1.46 acres of Khata number 18, total 6.90 acres in favor of one Badamiya Devi. The settlement was confirmed by grant of rent received by the ex-landlord in favor of the said Badamiya Devi, wife of Bandhu Pasi, and since then the settling became the Raiti land of the Bedamiya Devi. Said Bedamiya Devi came in possession of the settled land and started exercising her act of possession. Bandhu Pasi, husband of Bedamiya Pasi, were 4 brothers, namely Lakshman, Chulan, Dukhi Pasi, Bandhu Pasi, out of whom Dukhi Pasi died issueless. Chulan Pasi died, leaving behind his 2 sons, Banda and Bhutta Pasi. Lakshman Pasi died, leaving behind his son, Balkishun Pasi. Plaintiff number 1 and plaintiff number 2, Mahendra Pasi, son of Balkishun. Bandhiya Pasi, wife of Lakshman Pasi, was the own sister of Bedamiya Pasi. Bandhu Pasi died issueless. He fell seriously ill, and on account of financial crisis, he sold his house in the year 1939 to Jayanti Kwal. Thereafter, he died. Bedamiya then started living with Bandhiya Pasi. Said Bandhiya Pasi, out of love and affection, had taken settlement of 6.90
ठीक है,
acres. Sorry, ma'am?
ये out of love and affection. नया काम शुरू है ना यहाँ.
नहीं नहीं हम पढ़ रहे हैं बट क्योंकि settlement had taken settlement of 6.90 acres of land in the name of her sister Badamiya Pasi. The ex-landlord Mahant Brahm Prakash Das, after vesting of zamindari, submitted return wherein Badamiya Pasi had described and shown this as settling of 6.90 acres, including 5.44 acres of Khata number 106. After vesting zamindari, name of Badamiya Pasi was mutated in the Anchal office Chatra, which is still running in the name of Badamiya Pasi. Badamiya Pasi had no issue. So she treated Balkishun Pasi as her son. Badamiya Pasi died in the year 1960, whose cremation and shraddh was performed by plaintiff number 1. After death of Badamiya Pasi, plaintiff number 1 came in possession over the said 6.90 acres of land. In the year 1978, said Bhutta Pasi tried to dispossess the plaintiff from 6.90 acres of land. Hence, a proceeding under 144 CRPC was initiated at the instance of Bhutta Pasi, which was later converted into 145. After trial, 145 was decided on 1983, declaring possession of plaintiff number 1. Against this order, Bhutta Pasi preferred criminal revision, which was dismissed. Bhutta Pasi then filed partition suit in the court of Munsif Chatra with respect to 6.90 acres of land. The said suit was decided on merit on 17-90 in favor of defendant of the suit. Besides that, their possession over 6.90 acres was also declared and confirmed. Thereafter, defendant number 3 in June 1992 made illegal attempt to dispossess the plaintiff from the suit land, as a result of which proceeding under 144 was initiated with respect to 5.44 acres of land of plot number 8, which was converted into 145, which was ultimately decided against plaintiff number 2, which was the first party in the proceeding. In criminal revision preferred by the plaintiff against the said order was also met with same fate, which was decided on 37/2003. In the year 1992, plaintiff number 2 applied to Anchal Adhikari for cancellation of Jamabandi running in the name of Aitwariya Devi, defendant number 3. However, in the said application, plaintiff number 2 also complained against defendant number 4 to 6, who were trying to create problem with peaceful possession of the plaintiff over the rest part of the land. Anchal Adhikari examined the return submitted by the ex-landlord and Jamabandi register and found 5.44 acres of plot number 106 have been mentioned to be settled with Bedamiya Pasi, and demand in register 2 has been running in her name. He also found that 2 acres of land of plot number 106 have been settled by SDO in favor of one Bhuvneshwar Lal by settlement case number 27 of 6061. He also found that the SDO wide settlement case number 27 of 8687 settled 1 acres of plot to each different number 4 to 6. Not वो 4 to 6 है sorry मैं हम ठीक तो ठीक है वो सर गलत
थोड़ा सा correction हो
judgment अच्छा ठीक
थोड़ा correction हो
the Anchal Adhikari, though found that the settlement made by the ex-landlord of 5.44 acres of plot number 9 in favor of Badamiya Pasi is genuine and valid, and he also found that the settlement has been confirmed from the return submitted by the ex-landlord. The Anchal Adhikari also came up with a false story that since the time of settlement by SDO Chatra, the settlers Bhuvneshwar Lal and other settlers, that is defined number 4 to 6, are coming in possession of the respective part and parcel of plot number 106. The settlement made by SDO Chatra was only an illegal and without jurisdiction, but also not binding upon the plaintiff. The most important factor was not considered or ignored, that no settlement of royalty land can be made by the government in favor of anybody, treating the land as their mujurwa khas land. From the parcha granted in favor of defendant 4 to 6, it will transpire that the settlement was made in their favor in respect of the lands of Khata number 13. And the parcha was granted to defendant number 6, which will show that not only lands of Khata number 13 was settled, but also lands of Khata number 105 was settled. It is remarkable that even in the year 1986, when the LH settlement was made,
106 का तो कोई settlement ही नहीं है.
sorry, what?
106 का
Yes.
कोई settlement ही नहीं है in favor of defend number 4 to 6.
नोट इसको कंप्लीट कर लेते फिर वो करेक्शन हुआ जो पर्चा में लेटर करेक्शन हुआ any other sorry it is remarkable that even in the year 1986 when the alleged settlement was made in favor of defendant 4 to 6 the lands of Badamiya Pasi was shown to be existence and in 1986 none of the boundary of so settled land will defend number 4 to 6. Any land of either Bhuvneshwar Lal or Chunu Devi was shown existing. This alone fact is sufficient enough to project two things. One is that no part and parcel of land of plot number 106 and the Khata number 21 was settled with defendant number 4 to 6, and neither Bhuvneshwar Lal nor his alleged successor, that is Chunu Devi, possessed over any adjoining land. Hence, the suit filed against the defendant number 4 to 6 also, because they are trying to take possession. Plaintiff have further stated that after making search, they could trace out that Chunu Devi actually sold land of plot number Itna, pertaining to Khata number 18 to Dharam Rana, husband of Aishwarya Devi, through sale deed dated 1991, but they could not trace out sale deed of 1991. Exhibit 2M of Miss case number Itna filed by the second party. Aishwarya Devi, after alleged proceeding in the suit land, in a bid came in forceful possession of the same, attempted to dug the well and construct a hutman over the eastern portion of plot number 106, which gave rise to 144 CRPC proceedings. The learned executive magistrate dealing with 145 proceeding gave weightage to the settlement made by SDU and false and conclusive return of police and Karamchari ordered to remove to revenue authorities and did not take consideration of the finding of civil court. Criminal division Itna was dealt in the same manner, and therefore the plaintiff has been compelled to file the suit. Notice under section 80. Now, note very important paragraph 3. Your Lordship may see. State का क्या stand? The written statement was filed by defendant number 1 and 2. The pleading of these defendants in brief is that the present suit is legally not maintainable either in law or on fact. As such, the same is fit to be dismissed. There is no relief against these defendants, and they have unnecessarily been dragged in the suit. The plaintiff have not valid cause of action of the suit. The suit is barred by limitation, waiver, stoppel, since the suit is also barred by adverse possession and now. So the suit suffers from non-joinder or misjoinder of necessary party. Statement made in para 1 of the plaintiff is correct and admitted, with an addition that the nature of the land of Khata number 21, plot number 106, total area 5.44 acres was Gair Mujurwa Khas land. The statement made in para 2 of the plaintiff is admitted only to the extent that the entry in the Khatiyan that the ex-landlord was Brahma Prakash Das, but it is baseless or false to say that by these plaintiffs that the ex-landlord settled the land of Khata number 27, plot number 106, area 5.44 acres and other plots by virtue of Hukumnama in Sambat 1946 in favor of Padamiya Pasi. The said land was never settled by ex-landlord, and the said land, after vesting of the zamindari, vested in state. So this is the stand of the state. The said hukumnama and zamindari rent receipt are forged and fabricated documents, which is only for purpose to grab the land, which is in possession of defendant number 527 who was settling from the state, and the state had granted parcha and government rent receipt to this effect. The statement made in paragraph 3 of the plaintiff is false and hereby denied by these defendants. The said Vedamiya Devi never came in possession, and the land remained in control of and supervision of the state, and Anchal Adhikari Chakra has settled the land of the said plot 106, 1 acre in favor of Walok Paswan and 1 acre in favor of Parmeshwar Paswan to Sahari Paswan by settlement case number 27 of 8687, and they had granted parcha to them. But due to oversight and mistake, khata number 13 has been inserted in place of khata number 21. And remaining 2 acres of suit plot 106, khata number 21 has been purchased by defendant number 3, Aishwarya Devi, wife of Dharam Rana, and she is in physical possession over the same. So statement made in paragraph 4 and 5 of the plaint are required strict proof by the plaintiff. The statement made in paragraph 6 and 7 of the plaint bears no truth and hereby denied by these defendants. It is false to say that name of Vedamiya Pasi finds place in the return of the state. Lordship may kindly mark the stand is this. There has been granted. It is false to say that the name of Vedamiya Pasi finds place in the return and the state government has granted rent receipt in favor of Vedamiya. The statement made in paragraph 8 of the plaintiff is self-serving statement of the plaintiff. There is no proof that Vedamiya Devi has adopted Balkishan as a son. The statement made in paragraph 9 and 10 of the plaintiff required strict proof. The statement made in paragraph 11 of the plaintiff is partly true and partly untrue. It is false that plaintiff is in possession of the suit land. Rest portion of these para is required strict proof by the plaintiff. The statement made in paragraph 12 of the plaintiff is correct. The statement made in paragraph 13 of the plaintiff is required strict proof by the plaintiff. The statement made in paragraph 14 of the plaintiff is false to say that ex-landlord has settled 5.44 acres of plot number 106 and demand was opened and registered and entered in registered to. Anchal Adhikari has never examined any paper of Vedamiya Devi and never found the settlement of the ex-landlord for 5.44 acres of plot number 106 in favor of Vedamiya Devi.
Issues में है,
Sorry?
issues में है.
Yes. But issues start from
Page 57.
page 57, internal
And
page 90.
All issue is concerned with issue number 8.
If I succeed on issue number 8, Lord, definitely other defendants will fall. Now, Lord, issue number 8, your Lordship may kindly take note. Para 11 हम दिखाना चाहते हैं Lord, कि क्या these are documents filed with the plaintiff. Para 12 में on behalf of defendant number 1 and 2, who is the state, only one witness, namely Chandrasekhar Azad, has been examined, and no document has been filed. Now, your Lordship may kindly take findings. Page 22, internal page 22, running page 60. Paragraph 16. For the sake of convenience, this issue has been taken first. In this case, on behalf of plaintiff, some documents have been produced to support of his pleadings. Out of Exhibit 1 and 2 CD are revenue rent receipts including Jamindari rent receipt in the name of Musammat Vedamiya, which is of khata number 18 and 21. But no khata number has been mentioned in the revenue rent receipt. Exhibit 3A and 4A are acknowledgement of notice under section 80 CPC. Exhibit 5 is the order of SDO Chatra in the year 1977, filed by Bhutta Pasi. Exhibit 6 is the order passed by executive magistrate in case of so and so, filed by Bhutta Pasi. This case has been decided in favor of Partition. Exhibit 4B, which has been decided, but on perusal of Exhibit 4B, 5 and 6, it appears that all these cases were filed after 1977. But in these cases, defendants have not been made party, where, as per the document of defendant number 3 to 7, disputed land was settled by the defendant by the government during 1960-61 onwards, due to which these defendants have not been granted opportunity to contest. Exhibit 4 is judgment passed in partition suit 19 of 87. Chatra, which was passed in the year 1990, which was fought between Bhutta Pasi and Balkishan. In this case also, the defendant of this suit has not been made party, hence the judgment passed in this suit is not binding upon the defendant. Exhibit 8 is the decree passed in partition suit number 19 of 87. Exhibit 9 is the case or number so and so 90 of 96 in the Court of Commissioners Rajagh, which was filed by the plaintiff Mahendra Kumar against the defendant Aishwarya Devi. This case was also remanded back to the additional collector for passing fresh order. No any finding has been given by the learned commissioner. Not after Exhibit 9, the court reports, then Exhibit 11 is Hukumnama, which is important to document regarding the suit by which ex-landlord Brahm Prakash thus settled the suit.
Where is the discussion of exhibit 10?
Yes, not exhibit 10, next page, not page 24.
Page number?
Next page, ठीक उसका running page 62.
हाँ. Exhibit 10 का discussion.
Yes, ma'am. On perusal of fifth line from top notes, बीच में on perusal of exhibit 10.
Yes.
It appears that ex-landlord has filed a return of khata number 21, plot number 106 and khata number 18 in the name of Bedamia Pasi. So this is only recording at what is exhibit 10. Absolutely, my lords, there is no finding on exhibit 10. Let me place my lords from this.
And on the basis of which compensation was determined and paid.
Yes. And my lords, very
आगे finding क्या है?
नोट फाइंडिंग खाली है बेस पे कि हुकुमनामा में, क्योंकि जिसमें हुकुमनामा में योर लॉर्डशिप आई जस्ट रेफर्ड कि हुकुमनामा में लिखा हुआ है चैत वदी 13 सम्मत 1946 साल, तो दोनों कोर्ट बोल दिए कि क्योंकि हुकुमनामा आपका डाउटफुल है क्योंकि उस पे सम्मत 1946 लिखा है, तो 1946 से -57 करेंगे तो 1890 आ जाएंगे कुछ, तो उस समय सेटलमेंट हो ही नहीं सकता था क्योंकि बेदमिया जो है उस समय माइनर एज की होगी या नहीं बॉर्न हुई। खाली इस ग्राउंड पे हुकुमनामा को डिसबिलीव किया गया है। बोथ द कोर्ट्स हैव फेल्ड टू टेक इनटू कंसीडरेशन कि नोट हुकुमनामा, योर लॉर्डशिप इज अवेयर, नोट हुकुमनामा, डिलीवरी ऑफ पोजीशन, रेंट रिसीप्ट grants notes a valid settlement in terms of Ugni. Here notes I
Is
say
the finding of the court that the hukumnama is forged and fabricated?
but the court on this ground says it is forged and fabricated, but not the court does not take into consideration that my case is better than Ugni Devi's case because not I stand in a much higher footing, better footing, because in my name return is also filed, which is a statutory return in terms of BLR Act. And that aspect, because your lordship is aware, not there are several cases कि सादा हुकुमनामा आ गया, जमींदारी रसीद आ गया, and we say कि not we have a valid right in terms of Ugni Devi's judgment. Only on basis of this, I say not I have a return in my favor by the ex-landlord, which is of the year 19 at the time of vesting 53, 54, 50. I'll show that document also. And even I have not state rent receipts also, right from 55 onwards till 80s. That is exhibit. So not my settlement, even if हुकुमनामा में not 19, लेकिन 1946 के बाद साल भी लिखा हुआ है. So even if that document is interpreted, and if that document court says कि वहाँ पे क्योंकि सम्मत लिखा हुआ है 57 माइनस करना होगा, तो इसीलिए that appears to be forged and fabricated. वो फाइंडिंग हाँ, लेकिन एग्जिबिट 10 जो है कॉम्पनसेशन के, उसके बाद कोई भी फाइंडिंग नहीं.
Exhibit 10 is compensation.
कॉम्पनसेशन केस जो है जिसपे इन टर्म्स ऑफ BLR है, बट वहां पे जो हम दिखाए एग्जिबिट 10 को जो रेफर किए कोर्ट की क्या है एग्जिबिट 10, देन योर लॉर्डशिप में काइंडली नोट फ्लिप पेजेस एंड सी नोट पैराग्राफ वाइज कि कहां पे नोट नेक्स्ट पेज में नोट पेज 63 में एविडेंस कंसीडर किए हैं, एक एक पेज करके नोट पेज 63 रनिंग पेज 63 में PW2 3 जो है उसका एविडेंस कंसीडर किए हैं, देन नेक्स्ट पेज नोट 64 में वही PW का एविडेंस कंसीडर हो रहा है. Then the court says, page 65, on behalf of state only one witness, namely Chandrasekhar Azad, has been examined, who is the government employee, as Amin in Anchal office, Chatara, who has stated that disputed land was Gair Mujudwa Khas land recorded in the Khatianas forest after abolition of Zamindar. So income not be gavahi compensation. Yes. On behalf of the state, only one witness, namely Chandrasekhar Azad, has been examined, who is a government employee, as Amin in Anchal office, Chatara, who has stated that disputed land is Gair Mujudwa Khas land as recorded in Khatianas forest, and after abolition of Zamindari, the said land is vested in government and government is in possession of the said land. The plaintiff has filed forged and fabricated hukumnama. Name of Bedamia Pasin is not recorded in demand register, nor revenue.
Demand register has been exhibited.
Sorry,
Demand register has been.
demand register register 2.
Exhibit 1.
No, exhibit नहीं हुआ, उसके लिए हम लोग एक IA फाइल किए थे एडिशनल एविडेंस के लिए, that is pending.
आप उस समय क्यों नहीं किया at that date?
But that अप्रोप्रिएट टाइम नोट्स क्योंकि वहाँ मेंशन भले किए हैं प्लेंट में लेकिन उस समय नहीं किए थे क्योंकि अभी हम लोग आईए फाइल किए थे एडिशनल
सेकंड अपील
हाँ सेकंड plaintiff has filed forged and fabricated report. Name of Bedamia Pasi is not recorded in demand register. No revenue and receipt have been issued. This is the statement, which is not against these exhibits, which are government rent receipts. I will show from that. क्योंकि स्टेट गवर्नमेंट का भी रेंट रिसिप्ट है कंटिन्यूअस. दैट विल रिकॉर्ड नोट स्टेट का है एग्जिबिट 1 सीरीज.
आप स्टेट हैं, कौन है स्टेट इसमें? When the state is taking a stand कि रजिस्टर 2 में इनका नाम नहीं है, इशू नहीं हुआ है, तो रजिस्टर 2 प्रोड्यूस करने का काम किसका?
रजिस्टर 2 अगर रिलाई कर रहे हैं रजिस्टर 2 पर
स्टेट का काम था ना.
रजिस्टर 2 पर रिलाई कर रहे हैं कि
आप नहीं रिलाई कर, ये नहीं रिलाई कर रहे हैं, आप रिलाई कर.
ये रिलाई कर रहे हैं कि हमारा रिकॉग्निशन ऑफ टेनेंसी गवर्नमेंट है रिकॉग्नाइज.
आप लिखे हैं कि इनका नाम नहीं है डिमांड रजिस्टर. ये तो एक डॉक्यूमेंट प्रोड्यूस कर रहे हैं जो ऑन द फेस ऑफ इट इज इशूड बाय द स्टेट. Correct? Rent receipt issued by the state on the face of it. And you have taken a stand that इनका नाम डिमांड रजिस्टर में नहीं है. तो कोई तो डिमांड रजिस्टर चेक करके किए होंगे ना. हाँ तो कहाँ है? क्यों नहीं एग्जिबिट किए?
वेरी फाउंडेशन ऑफ द केस ऑफ द प्लेंट.
नहीं आप हमको जरा इस पर थोड़ा आप सोचिएगा. इन्होंने तो एडिशनल एविडेंस फाइल कर दिया. जब आपका स्टैंड है तो आपको प्रोड्यूस करना चाहिए था. एडिशनल एविडेंस का क्या काम है?
हाँ ठीक है, लेकिन इन्होंने केस लाया, स्पेसिफिक केस लाया है कि हमारा सेटलमेंट हुआ था. सेटलमेंट के बाद हमारा गवर्नमेंट ने रिकॉग्नाइज किया टेनेंसी वाला दिखाया.
We'll see that. We have to confine to the question of law.
Yeah.
But still, if a person asserts with reference to a particular document, document को exhibit कराने का काम उन्हीं का है ना? Isn't it?
जो वही कर रहे हैं तो है क्योंकि सक्सीड
आप सरकार है, आपका क्या है बात?
नहीं ऐसा सर नहीं सरकार है तो
नहीं आपकी मानता पर हम चाहते
नहीं मानता.
इनको भी जरूरत नहीं था जमा करने के लिए क्योंकि PW1 जो बालकिशोर पासी है जो अपीलेंट है उन्होंने खुद कहा कि मेरे नाम से कोई डिमांड नहीं है. अपने डिपोजिशन में कहा कि मेरे नाम से कोई डिमांड नहीं है. हमने एटवरिया टीवी डिपेंडेंट नंबर 3 मेरे जो म्यूटेशन है डिमांड को कैंसिल करने का हम एप्लीकेशन दिए.
अच्छा कोई बात नहीं. हाँ
एविडेंस
आप बैठिए हाँ बताइए.
Yes. Lord में also Lord make a note. ये जो स्टेट की तरफ से जो विटनेस आया है कि ये गवाही दे रहे हैं in 2007 and his age at that point of time is 32 years. तो 2007 में ये गवाही दे रहे हैं of vesting का और डिमांड का और कि
तो रिकॉर्ड ही देके देंगे ना. सरकारी गवाह तो
रिकॉर्ड देख के देंगे.
उसके बियॉन्ड तो कुछ
उसके बियॉन्ड नहीं देंगे. इसीलिए लॉर्ड इट वाज मोर ऑल द मोर इम्पोर्टेंट टू प्रोड्यूस दिस कि हाँ देखिए इनके नाम से कॉम्पनसेशन केस नहीं है.
एग्जिबिट 10 दिखाइए.
यस एग्जिबिट 10
लाइए. ये भी इस पे एग्जिबिट 10.
But can I flag that? तो क्योंकि काफी सारा एग्जिबिट और एग्जिबिट 10 4-5 पेज. हाँ
और इसी के बेसिस पे कॉम्पनसेशन भी करें.
हाँ क्योंकि these are not statutory in terms of the Bihar Land Reforms Act section 456.
अच्छा एक बात बताइए.
Yes.
रिस्पोंडेंट अनरजिस्टर्ड हुक्मनामा का तो कोई वैल्यू
हाँ ये एडिशनल एविडेंस.
नहीं है. लेकिन अगर किसी को जमींदार ओरली सके और जमींदारी रेंट रिसीट, लेट अस अज्यूम हुक्मनामा नहीं है लेकिन जमींदारी रेंट रिसीट है, उसका क्या वैल्यू? और रिटर्न में इंक्लूडेड भी है, इसका क्या वैल्यू?
तब जो सब्सिक्वेंट कंडक्ट है कंसीडरेशन में आएगा.
क्या सब्सिक्वेंट? रिटर्न में इंक्लूजन इज एन इंपॉर्टेंट थिंग. उसको इग्नोर कैसे करिए?
हाँ इग्नोर नहीं किया जा सकता है
उसको. एंड यू हैव एक्टेड पर्सनली टू दैट. कहानी खत्म है वहीं पर. रिटर्न में इंक्लूडेड है, आपने उसको कर लिया है, उसके बाद इन्होंने रेंट रिसीट प्रोड्यूस कर दिया और आपने जो है
बट ऑन द बेसिस ऑफ रिटर्न इनका डिमांड उसी के आधार पर ओपन हुआ कि नहीं, ये तो देखा जाएगा।
नहीं हुआ तो क्या हुआ, नहीं हुआ तो
क्योंकि-
क्या हुआ,
क्योंकि-
इंटरटैटिंग खत्म हो
क्योंकि
गया।
रिटर्न समटाइम यूनिलैटरल एक्ट है, क्योंकि रिटर्न तो ये
नहीं, आप एक्सेप्ट
नहीं,
करते हैं
return
ना,
हम कहाँ file
यूनिलैटरल एक्ट कैसे, यही तो बोल
हाँ तो
रहे हैं।
लैंडलॉर्ड भी
रिटर्न इज एन यूनिलैटरल एक्ट, बट यू एक्ट पर्सुएंट टू द रिटर्न ना, आप वेरीफाई करते हैं कि ऐसे आंख बंद करके करते हैं,
तो वेरीफाई का तो है ही
है ना, वेरिफिकेशन होता
हाँ,
है,
verification।
कॉम्पनसेशन तय होता है कि भाई इतना इनका जमीन है, इसको एक्सक्लूड करना है, इतना रैयती
अपना
हो गया।
लैंडलॉर्ड का जो बकास्त होगा, अपना जो खुद कास्ट
वो
होगा,
बकास डिटरमाइन करने के लिए रिटर्न इंपॉर्टेंट है ना,
रिटर्न इम्पोर्टेंट है। और
तो फिर?
एआर के से माल वही बंधेगा 5 6 7 में,
तो फिर?
जो उनका अपना बकास्त का है।
तो
और जो-
फिर?
लेकिन तब उस पर जो ये
उसके बाद अगर मान लीजिए आप पे रजिस्टर 2 में एंट्री है नहीं, इसका क्या रेलेवेंस?
लेकिन जब वेरी फाउंडेशन इटसेल्फ फॉल्स,
फाउंडेशन इज
क्योंकि इनका
द
टैक्स
जमींदारी आपका होल्ड कर दिया हुक्मनामा करने ऑन अ ग्राउंड व्हाटएवर, ठीक है,
तब पोजीशन भी तो देखा जाएगा कि इनका पोजीशन
क्या
है
पोजीशन?
कि पोजीशन में है कि नहीं उसके उस जमीन के बारे, क्योंकि जो
पोजीशन तो आप सरकार, आप जिसको दे दीजिए उसी का हो जाएगा पोजीशन।
नहीं, सरकार तो अपना एडवर्स पोजीशन नहीं ले सकती है, सरकार एडवर्स पोजीशन नहीं क्लेम कर सकती है। अभी
अभी
recent-
क्लेम ही कर रहे हैं आप, वही कर रहे हैं।
नहीं सरकार नहीं कर सकती है, लेकिन
एग्जिबिट 10 निकाल के दीजिए,
हाँ।
10 में
आपको क्या बोलना है एग्जिबिट 10 को बताइए।
ये वाला फ्लैग बताइए पहले और उसके बाद एग्जिबिट।
एग्जिबिट 10 में एक चीज हम दिखाते हैं,
हम देखेंगे
हाँ
एग्जिबिट 10
एग्जिबिट
इनका जमींदारी रेंट रिसीट का भी फॉल्ट है बोल के फाइनिंग है,
नहीं,
Not
ओवर राइटिंग है रिटर्न में, ये इनके ही विटनेस एक्सेप्ट किए,
इससे क्या मतलब?
इसलिए कि वो जो विटनेस है
हाँ,
वो
वो दिखाइए,
लैंडलॉर्ड
हाँ,
के
सर।
ही रिलेटिव।
Third वाला
कोई ऐसा फाइंडिंग है कि एग्जिबिट 10 फोर्स है?
हाँ, नहीं उसमें
कोई
फाइंडिंग
ऐसा भाई दोनों कोर्ट से अब जीते हुए हैं, कोई ऐसा फाइंडिंग है कि रिटर्न इज फोर्स?
return is foreign and it has not been taken into consideration because there is no
बिकॉज कहाँ से जर्नल से बिकॉज दिखाइएगा
हाँ,
ना,
ये वही तुम पढ़ रहे
दोनों
हैं
flag लगाओ।
पारा 26
वो
पेज 26
being co- जो वाला
PW7 is
flag है,
also
हाँ, वो।
formal witness who has proved compensation
वो दिख-
case number 40
हाँ, वही।
1953-54 in para 28 he has stated that there is overwriting in the return but there is no initial signature upon cutting and overwriting. There is no signature
Lord, your
of
lordship please
survey
note that वो बेदमिया पासिंग के नाम से है,
सूर्यनारायण
जो
प्रसाद
दो फ्लैग लगा हुआ
document
है, पिंक और ब्लू वाला।
in para
बेदमिया पासिंग अब उसे
48
लॉर्ड
and 49 he has
3/4 फ्लैग्स
stated that there are
पेज पहले
remaining
पिंक फ्लैग लगा
there
कॉम्पेंसेशन
with
केस
Jerwala.
का, यहाँ से स्टार्ट होता है डॉक्यूमेंट।
PW7 he has demolished the case of the
एक
plaintiff.
सेकंड, ओवरराइटिंग कहाँ है? बेदामिया पासिंग के तो उसमें कहीं कोई ओवरराइटिंग नहीं है।
That is the finding. It's
दिखाइए।
so it has been stated.
अब देखिए
हाँ,
बेदामिया पासिंग का जहाँ एंट्री है वहाँ कोई ओवरराइटिंग नहीं है। जिसका ओवरराइटिंग है उसको आप जो मर्जी करो।
लॉर्ड वो तो नहीं कह सकते, सरकार बहादुर कर
नहीं
ओवरराइटिंग में।
मेरा तो सेटलमेंट हुआ है,
हाँ, तो वही-
सेटलमेंट चैलेंज में नहीं है, इसलिए हम तो रहेंगे।
अगर स्टेट का राइट टू सेटलमेंट नहीं रहेगा तो आपका कुछ भी नहीं रहेगा।
लेकिन एक सेक्शन 34 ऑफ स्पेसिफिक रिलीफ एक्ट भी है कि इनको उसके अगेंस्ट में रिलीफ मांगना है ना, बिकॉज़ दैट विल कॉज इंपेडिमेंट इन डिक्लेयरिंग द टाइटल।
हम तो सब्सटेंशियल क्वेश्चन ऑफ लॉ पे ही जाएंगे।
हाँ तो सब्सटेंशियल क्वेश्चन ऑफ रिटर्न पर बना हुआ है, और जो एआईआर 1968 पर बना हुआ है, उगली देवी बनाम चुआ महतो का केस पर बना हुआ है कि वो एडमिसिबिलिटी रिगार्डिंग एडमिसिबिलिटी ऑफ द हुक्म।
हाँ दिखाइए एग्जिबिट 10 का और डिस्कशन।
हाँ, तो लॉर्ड आफ्टर दिस नोट वी वर ऑन पेज 65 नोट, बट देन योर लॉर्डशिप में टर्न नोट नेक्स्ट पेज 66 एग्जिबिट ई का डिस्कशन है। देन नोट लास्ट जो लाइन है ऑन बिहाफ ऑफ डिफेंडेंट नंबर 3 एंड 4 पेज नेक्स्ट पेज नोट, फिर डिफेंडेंट का गवाही को कंसीडर कर रहे हैं पेज 68 में लास्ट लाइन फ्रॉम पेरूजल, क्योंकि तब तक डिफेंडेंट का गवाही को है
हाँ बिल्कुल।
on from perusal of the evidence of all these witnesses may I place this?
Yes.
All these witness, it appears that these defendants have fully supported the pleadings of defendant number 5 to 7. Nothing has come in cross-examination in favor of the plaintiff. On perusal of evidence available on record, it appears that defendant number 3 to 7 are in possession of the suit land allotted to them by the ex-landlord, which have been admitted by the plaintiff witness and also by which has been proved by the documents filed on behalf of plaintiff as well as defendant. Although plaintiff have filed revenue rent receipt
No,
regarding
I just.
sorry, what?
They are in defendant number 3 to 7 are in possession of the suit land allotted to them by ex-landlord.
No, by the state. By the state. Okay, ex-landlord नोट 60 और 80 में हो ही नहीं सकता.
Wait, आगे.
Although the plaintiff have filed revenue receipt regarding the suit land as per Exhibit D, it has been stated by the additional collector that revenue rent receipts of the year 86, 87, 92, 91, 91, 92 revenue receipts 79, 80 have been issued by 2 continued volumes, which creates suspicion. Before issuing revenue rent receipt, it is necessary that demand be opened in the name of plaintiff, but in this regard, no document have been produced on behalf of the plaintiff, which goes to show that plaintiff have applied before the competent authority regarding opening of demand. On perusal of Exhibit F, it appears that the learned LRDC has given a finding that hukumnama and return of the plaintiff have not been verified by compensation case by Anchal Adhikari, Halka Karamchari and Anchal Adhikari have verified on the spot and disputed land is found in possession of defendant number 3 to 7. On perusal of the evidence, it also appears that learned SDO has settled the land to one Bhuneshwar Lal in 1960-67 and again settled in 86-87, but no any objection have been filed on behalf of plaintiff. It means that the plaintiff that time plaintiff was not in possession of the suit land. Hence, I find that hukumnama produced on behalf of plaintiff are not genuine documents. Where is the consideration of Exhibit 10? Absolutely no consideration. So, on basis of said hukumnama.
Exhibit F क्या?
Sorry.
What is Exhibit F?
Exhibit F notes have been produced by these defendants, and this Exhibit F is all the but these are mutation proceedings order जो इनके नाम पे चल रहा था सेटलमेंट के बेसिस पे, उसको हम लोग कैंसिलेशन के लिए गए. So these are all after 60s and 80s.
So Exhibit F
Yes,
में he has given a finding that hukumnama and return of the plaintiffs have not been verified in the compensation case.
66 ये
कहाँ से दे देंगे?
क्योंकि वो सेटलमेंट पे पर्सुएसिव हो गए क्योंकि इनके नाम से सरकार सेटल कर दिया 60 और 80s में.
Exhibit F के तो आप पार्टी भी नहीं है.
F के पार्टी भी नहीं है मिलोट्स. हम म्यूटेशन प्रोसीडिंग में एक डॉक्यूमेंट का फाइंडिंग दे करके जो कि पहले क्रिएट हुआ क्योंकि सरकार इनको सेटल कर दिया था तो अंचल अधिकारी और अंचल अमीन मिलोट्स तो सरकार की तरफ से ही है तो वही कर दिए कि हुकुमनामा इनका डाउटफुल है, ये फाइंडिंग दे दिए. एंड एग्जिबिट 10 पे मिलोट्स एक लाइन भी फाइंडिंग नहीं है. अपीलेट कोर्ट जो है सेम मिलोट्स एग्जिबिट 11 अपीलेट कोर्ट एक बेटर काम किया इसे कि 2 पैराग्राफ और मतलब 2 पैराग्राफ नहीं सॉरी 2-3 लाइन एग्जिबिट 10 के बारे में लिखे है और कहीं एग्जिबिट 10 को हाँ अपीलेट कोर्ट नोट्स. यहाँ तो यूनिवर्सिटी पे सीन ट्रायल कोर्ट पे तो कहीं फाइंडिंग नहीं है, अपीलेट कोर्ट देखा.
सर्कल ऑफिसर से मंथली मीटिंग जरूरी नहीं है क्या झारखंड में? मंथली मीटिंग विद सर्कल ऑफिसर है ना जरूरी. रिटर्न गलत है इनके म्यूटेशन ऑर्डर में कर देंगे.
वेरिफिकेशन तो किया जा सकता है.
क्या वेरिफिकेशन?
लेकिन
रिटर्न का वेरिफिकेशन जस्ट अ मोमेंट. रिटर्न का वेरिफिकेशन करने का क्या जुरिस्डिक्शन है? जब रिटर्न 1950 में फाइल हो गया उस पर कॉम्पेंसेशन
कुछ चीज हमें नहीं कहनी चाहिए जो अब कहीं से
बहुत क्यों नहीं कहना चाहिए आप
फेक
बट ये सरकार इनको सब चीज कहना चाहिए.
बहुत फेक डॉक्यूमेंट हम अपार्ट फ्रॉम दिस केस बहुत फेक डॉक्यूमेंट भी प्रोड्यूस होता है.
क्या चीज पे फेक डॉक्यूमेंट?
हां बहुत फेक.
आप क्यों नहीं एफआईआर करते?
हां बहुत फेक डॉक्यूमेंट
करिए आप एफआईआर खुल के. फेक डॉक्यूमेंट है
माने अभी इस केस के बारे में
इसीलिए किसी को मत छोड़िएगा. हल्का कर्मचारी को, सर्कल इंस्पेक्टर को, सर्कल ऑफिसर को से लेकर पूरा राज्य के हर पदाधिकारी, आपको फेक डॉक्यूमेंट मिले आप एफआईआर करिए. वो तो एक भी नहीं करते.
कुछ होता है ऐसा नहीं
कुछ कुछ होता है, मतलब जो मिलता नहीं ठीक से,
कुछ होता है जहाँ पकड़ा जहाँ होता है
सिलेक्टिव नहीं हो सकते
नहीं
हैं।
सिलेक्टिव नहीं कुछ
Oh, my lord, I have said absolutely pinpoint answer.
देखिए सरकारी वकील को इतना पता है कि मिलने का क्या मतलब होता है, इसके
आप
बियॉन्ड हम
इसके
क्या
क्या
बोल सकते हैं?
नहीं मैंने
मतलब इतना नॉलेजेबल है झारखंड
नहीं
के बारे में।
जो
सर नहीं कर सकते। बताइए कहाँ?
सिलेक्टिव नहीं होता है, कुछ एविडेंस चाहिए किसी पर तभी
आप एविडेंस पर रिकॉर्ड के बाहर आप कुछ सुनते
हाँ
नहीं।
इसीलिए
Appellate order जो पारा 29
हम दिखा सकते हैं।
आज तो नहीं हो पाएगा ये कंप्लीट। एनीवेज बताइए।
Yes. नोट फाइंडिंग स्टार्ट होता है रनिंग पेज 24 से। देन यू लॉर्डशिप में टेक नोट्स।
आप खाली एग्जिबिट 10
एग्जिबिट 10 पे कहीं कुछ है ही नहीं। एक हाँ ठीक है 29 ठीक है 29
इनके मन का पालेगा।
हाँ हाँ 29 पढ़ PW2 जो है PW7 सॉरी पैरा 29 महंत गोपाल दास is said to be the successor of ex landlord Brahm Prakash Das. According to him, Brahm Prakash Das died in the year 1975 and white compensation case number itna he has submitted return of village Pakadiya serial number 27 in the name of Badamiya Pasin finds mention which is related to the land of khata number 18 and 21. According to his para 9, the return was signed by the ex landlord in his presence, but he has admitted in para 28 that there are cutting and overwriting without initial signature on that return. Though return was scribed by Suraj Narayan Prasad, but the signature is not available on it. In para 50, he has admitted that several rayats are in possession according to the settlement paper by the state. In para 70, he has admitted that Hukumnama Exhibit 11 was settled in the year settled in Sambat year 1946, and when Anand Prakash Das was the Mahant, but according to his para 3, he was born in Sambat 2002. If these facts are taken together, it appears that he was not born in Sambat 1946 when Exhibit 11 is said to have come in existence, but according to this para 47, in the year 1952 when the return was filed, he was of age of 35 years. He has admitted in para 2 that the plaintiff number 2 was produced him as witness. Thus, on appreciation of all these factors as stated above, it is also appears that he has no correct knowledge of relevant fact, but has come to depose with vested interest. Thus, he is not reliable witness on the point of filing of genuine return. So, this is the finding now, that he is not a reliable witness. Therefore, on factual aspect of possession, also no reliable witness have been produced by the appellant in the lower
You
court.
see, two things are important. Is it your case that the return was never filed? That is not your case. Nor can it be your case.
हाँ वो भी
Is it your case that in the entries relating to Badamiya Devi there is any overwriting? No, that is not your case. पूरे रिटर्न में कहीं पे कोई ओवरराइटिंग होगा तो पूरा रिटर्न गलत हो जाएगा। आपको उठा के फेंक देना चाहिए था उसी समय जब रिटर्न फाइल हुआ।
had not been examined while accepting return, लेकिन उसमें सिग्नेचर भी नहीं है, ये भी फाइंडिंग है।
स्टेट ने रिजेक्ट कर किया रिटर्न।
लेकिन रिटर्न को प्रूफ कराने का जो मोड है रिटर्न
क्या मोड है? आपने उसको you have acted pursuant to the return is more than sufficient.
रिटर्न को ओरिजिनल मंगाया गया कि
You have acted pursuant to the return is more than sufficient.
वो जो है जब रिटर्न जो एक पर होगा एक्ट होगा लेकिन प्रूफ कराने का मोड
The arguments have remained inconclusive. आज तो नहीं होगा, कब होगा? कल।
हाँ ठीक कल ठीक
10:30 बजे आ जाइए।
ठीक
ठीक है, कंटिन्यूटी में करेंगे। थोड़ा रिटर्न नोट्स बनाइए।
सेकंड
हाँ हम बना
सेकंड हाफ में रखा जाए।
5 बजे सेकंड हाफ
नहीं
नोट्स बनाइए आप लोग। सेकंड हाफ में आप लोग होमवर्क करिए। नोट्स बनाइएगा तो हाथ की हाथ लिखा देंगे
हाँ
और नहीं बनाइएगा तो फिर ऑर्डर रिजर्व यू नो।
no notes I will not take that is I will
You
prepare
don't-
the short notes
आप नोट्स बनाइए।
but can I hand over the judgments on which I am relying
आप जो भी हैंड ओवर करना है आप करिए
ठीक है, my friend will give you
फॉर फर्दर हियरिंग।